Good afternoon, everybody. My name is Oliver Westmoreland. I am an ISC registered Level 3 immigration advisor and senior immigration lawyer at GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is this. Your immigration application is refused. You appeal to the First Tier Immigration Tribunal. Your appeal is dismissed. What do you do then? What can happen? It's quite a large, complex topic. I'm going to go through it at a fair pace. I'm sure that Mr. Shah is building up loads and loads of questions about it. Some immigration applications have the right of appeal to the First Tier Immigration Tribunal if they're refused. For example, family visas, 10-year continuous long residence visa applications, private life applications, EU settlement scheme applications, and a few others. Other types of application don't have the right of appeal. They might have the right to, for example, administrative review. Some types of application which have a sort of a human rights character, you might say, if they're refused, there is the right of appeal to the First Tier Immigration Tribunal. This is something that comes of legal right. You don't need to have any special reasons. If you want to appeal against the refusal, you can just do it. Well, or your lawyer can do it, probably more sensibly. You can apply for either a paper hearing, which is a contradictory term. It means everything is done on the paper, so there is no hearing in front of a judge. Judge just makes a decision in his or her office on the basis of the papers. Or, sometimes better, not always, but sometimes better, an oral hearing physically in the tribunal, somewhere in UK, in front of a judge with lawyers and the whole paraphernalia. To cut a long story very short, if your appeal before the First Tier Tribunal is successful, the refusal decision is overturned and you get the visa. Well and good. But of course, what happens if it's unsuccessful? This is the question. There is the potential right of challenge to the Upper Immigration Tribunal against a refusal by the First Tier Tribunal. But very, very, very importantly, when you challenge, you must identify an error. In a lawyer's language, error of law, but that doesn't really mean anything. It's an error, a mistake, and also importantly, a material error, an error that would have made a difference. If there was definitely an error, but the error wouldn't have made any difference one way or the other, it's not enough. It needs to be a material error in the judge's decision, something that would have made a difference. Now, there's a whole load of possibilities as to what kind of error it could be. This term, error of law, well, it can be more than that. Judge has misunderstood the law, has interpreted the law incorrectly. That's a pure error of law, but other things also qualify as an error of law, but are different. Judge didn't interpret the evidence correctly. Sometimes judge doesn't take account of all the evidence. More generally and vaguely, the judge conducted an unfair hearing. There are all sorts of ways that a hearing can be unfair, but clear and obvious example, the judge evidently takes sides in a hearing. Now, of course, judge is supposed to be impartial, like a football referee, as they say, which is actually a very good illustration. Judge is supposed to be impartial between one side and the other. Supposed to make a fair decision. Judges are all about fairness. If it is the case, or if it's alleged to be the case that the judge took sides, then that could make an unfair hearing, and an appeal to the an appeal can be made to the Upper Immigration Tribunal on that sort of basis. There are other possibilities as well, probably. Anything that was wrong, allegedly wrong, and was material, anything like that, and maybe a few other possibilities. Let's say there was something that's procedurally incorrect during the hearing, for example. All these kind of things. You, or possibly your lawyer, probably your lawyer, because this work is quite difficult, can make an application to challenge the decision. Now, The application comes in two stages. First stage, you have to appeal to the First Tier Tribunal and say, we think your decision was wrong, unfair, bad because of so and so and so and so and so and so. They will consider that application. They may accept it, they may reject it. If they reject it, you or your lawyer gets a kind of second bite of the cherry to the Upper Tribunal. So when it is said there's a right of appeal to the Upper Tribunal, this is true, but initially the challenge is made to the First Tier Tribunal. That is, if not successful, then the challenge can be made to the Upper Tribunal. The challenge to the Upper Tribunal is probably going to be pretty much the same as the challenge to the First Tier Tribunal. It doesn't have to be completely different. All these things are by legal right. You don't have to produce any special reasons, but in both cases, the tribunal can decide not to accept the application. It's a discretionary decision. Classic grounds of refusal, they say, we think that your disagreement with the decision is just a disagreement with the decision. It's not, you haven't clearly established an error on the part of the tribunal. This is what it's about, an error. If you get a decision you don't like, you say, oh, I don't like it, it's not fair. But you have to disclose or attempt to disclose or identify an error and a material error. Now, if you're unsuccessful before the Upper Tribunal, you're in deep trouble. That's not quite the end of the road. I don't want to go into too much depth about this because we're getting to sort of very rarefied level, but just let me tell you very, very briefly, there is further right of challenge beyond the Upper Tribunal. It's something very, very difficult. It sounds funny, it's called CART, JR. It's nothing to do with horse and cart. CART was the name of an appellant in a case many, many years ago. This case established that even decisions of the Upper Tribunal could be challenged in judicial review. Judicial review is where a senior court looks at a decision by a lower court. When the Upper Tribunal was created a good few years ago, it wasn't very clear whether decisions of the Upper Tribunal could be challenged. Some people, well, maybe that's the end of the road. In a strange way, the law was not written very clearly, as sometimes happens. I'm just going to tell you very, very briefly, indeed, you can challenge a decision of the Upper Tribunal by way of CART judicial review, but I'm not going to go into any further into that today. Mr. Sharp, this is a very huge topic. I'm sure you've got some interesting questions for me.
Yes, thank you so much for diving into it. My first question is, if an appeal is dismissed by the First Tier Tribunal and the appellant asks for permission to appeal from the FTT, who looks at that decision at the FTT, the same judge or a different one?
It will never be the same judge. As far as I think, it's a cohort of judges who may be First Tier Tribunal judges or even Upper Tribunal judges. It's a special cohort of judges who look at these. You will never get the same judge assessing a decision made by that judge. It never happens.
Sure. And let's assume the permission to appeal at the FTT was dismissed as well, and it had to move on to submit the permission to appeal directly to the Upper Tribunal. What if the Upper Tribunal agrees with the appellant that you are actually correct with your submissions, and what is the next step? What happens next?
There will be some sort of hearing before the Upper Tribunal, and they will... the way that you said it, the Upper Tribunal hasn't completely made up its mind that there was something wrong with the First Tier Tribunal decision, but they think there might be arguable error. There will be some sort of hearing before the Upper Tribunal to decide carefully and in detail. It could be the Upper Tribunal in central London or somewhere else. They will make a detailed decision as to whether they really do think that the First Tier Tribunal decision was wrong or showed error or showed material error. If so, there are two different possibilities. They can actually remake the decision. The Upper Tribunal can remake the decision, which means that the appellant's going to be successful. Or they can not remake the decision, but say there's definitely some problems with the First Tier Tribunal decision. We direct the First Tier Tribunal to hear that case again with a different judge.
Okay.
But of course, it could be refused again. It's possible.
Yeah. And would I be correct in assuming that the Upper Tribunal has the power to overturn the decision completely and
Yes.
grant the visa?
Yes.
And does the Home Office have the right to challenge Upper Tribunal's decision?
Yeah, I suppose they could. They could challenge it in the Court of Appeal.
But is that a usual practice?
No.
Hardly.
No.
Okay, brilliant. And now, what if the Upper Tribunal can it half agree and half not agree? What happens?
Well, look, at the end of the day, the Upper Tribunal has to decide whether it was correct not to grant that visa or immigration permission. They might say various funny things, but really, at the end of the day, Upper Tribunal says either it was wrong or it was right to not grant that visa. That would be the important thing. They might say a few funny things as well, but it wouldn't be really important.
Let's assume the appellant went to the Upper Tribunal as well and it got dismissed there. They decided to do the challenge in judicial, in the co-judicial review. In the
Listen, this is very, very, very difficult application. It's highly restricted.
Wow.
It has to be a case of huge significance and importance.
So it's possible that even though the appellant wants to go that side, but it's just not allowed because there's no scope.
It's not allowed. Anyone can try anything. Sure, they would instruct a high-powered barrister to try and make that application, but as I say, it's very difficult, very restricted. You'd have to have a very strong case which showed some really fundamental legal error that had somehow got all the way through past the Upper Tribunal. I think it's going to be very,
very difficult.
Statistically rare for a case to get that far.
True. So if an appellant, either they get to it or they may not get to it, perhaps they accept their fate at the Upper Tribunal, the case is dismissed. Now,
well, I think a lot of people might accept their fate at the First Tier Tribunal.
True.
If they get legal advice that the First Tier Tribunal decision was good, fair and proper, they might not bother to appeal to the Upper Tribunal.
Sure. Now, if that happens and the end of the road comes, can the appellant start all over again by submitting a fresh application, maybe perhaps with same or different circumstances?
Mr. Shah, we're now getting into what is called paragraph 39E of the immigration rules. If you have a refusal and you appeal, ultimately it's unsuccessful, you have the right to submit a fresh application after that. You'll have to pay me extra because I didn't know that we were going to go into this area in this topic.
Sure. When someone does a fresh application, I would imagine the Home Office would look at their previous home applications and perhaps take those submissions into consideration.
I wouldn't worry too much. This is an immigration application. It's not like an asylum claim. Home Office will treat it as a normal application. I mean, this is probably going to be something under the immigration rules, isn't it? You know, a working visa or a study visa or something. I think the Home Office will consider it in a normal way.
Sure.
But I suppose there could be bad complexities if there are allegations of deception or dishonesty. That could mess things up, probably.
True. Yeah, that would be very negative for the applicant.
Don't forget, I mean, I suppose if the original refusal was based on allegations of deception or dishonesty and the appeals were ultimately unsuccessful, there might not be any point in making a fresh visa application because you know it's going to be refused for exactly the same reasons.
True. Okay. Exactly. Unless there are new circumstances that may surface and new reasons to stay and...
Yes, but if you're alleged to have done dishonesty or deception, you can't wipe that out quite so easily. It doesn't stay on your record forever, but it will stay there for a few years or so, probably.
Wow. Okay, this is quite complex area, isn't it?
Quite tiring, really.
It is, and we've tried to cover possible scenarios for our clients that they usually find themselves in. Perfect. I think today's vlog has been great, and I thank you for that.
I thank you as well, Mr. Shah.
And we see you in the next one.
See you next time. Goodbye, everybody.